Here, for the field in the state of Michigan is now exactly the Honorable Christopher Mourich, the Honorable Christopher P. Yates, and the Honorable Susan Youthfeld. Always have to be considered, draw your attention. Actually, the United States.
Good morning. Welcome to our second day of the January 2025 call. I am Judge Seema Patel, and I have the honor today of sitting with Judge Christopher Murray and Christopher Yates. Before we get started, a couple of ground rules. We have a few cases today that deal with protected individuals and children. Our proceedings are recorded. So I just want you to be mindful to not use any identifying information such as names, etc. With that, otherwise, this time is yours. Please use it as you see fit, and we are ready to begin. First case on our docket is number 14, docket number 368963, Mourich versus Burden.
Good morning, Your Honors.
Good morning.
George Danini from the Butzel Law Firm on behalf of Kathleen.
We're not going to hear you unless you're at the mic. Sorry, it doesn't pick up that far away.
My voice usually projects, but thank you for that. Good morning, Your Honors. George Danini from the Butzel Law Firm, appearing on behalf of Kathleen Burden.
Good morning, everyone. I'm attorney Kyle Bristow. I represent appellant Marianne Henry.
So who's arguing for appellant?
I will speak first, Your Honor. I will be very brief if it pleases the court. All I would like to say is I will direct Your Honor's attentions to the thorough brief that I submitted. I'm here to answer any questions that the court has for me, but I would like to relay that I corresponded with my client's criminal defense attorney yesterday. The criminal cases against the defendants are still pending, although the preliminary examinations have concluded. The district court judge has not yet made a decision regarding bind-over. Briefs are due March 30th, 2025. The bind-over decision will be made thereafter. And I also would just like to relay that the issue of what should happen to a civil case while there is a pending parallel criminal prosecution is very common. I have, other than this case, 3 other active cases involving this very issue. And trial court judges deal with them all in different ways. Some judges don't issue stays, which is what happened in this case. Another judge outright stayed the entire case. For another case, the judge prohibited discovery against my client, but otherwise allowed me to utilize discovery devices against the opposing party. So I'm just hoping that we can obtain some clarity as to
well, doesn't that kind of cut against your argument? Because it's an abuse of discretion standard and different judges handle it different ways. And this one did it. She's being flexible, saying you can come back if there's some issues that come up. I mean, even if I would have entered a stay, how is this an abuse of discretion?
Right. So I would direct Your Honor's attention to page 17 of my brief, the Eastern District of Michigan opinion by Judge Ludington.
We're talking about Wygant versus Woodcock and the 6 factors?
Yes, Your Honor.
There are 5 factors.
Right, absolutely. There are a number of different factors that the Sixth Circuit uses. And ultimately, if these factors are taken into consideration for purposes of our civil action, our case, the stay should have been ordered.
But if you balance the factors, as Judge Murray points out, you wind up at a decision that's insulated from review except for abuse of discretion, right?
I can't comment on that.
Well, but I think you've conceded that it's abuse of discretion review, right?
Yes, Your Honor. I do believe it's an abuse of discretion review.
And so even if the trial court painstakingly goes through all the 5 factors and makes findings, I think you've conceded that some could come out in favor of a stay, some could come out against a stay. But in any event, as Judge Murray points out, it's hard to say that that could ever be an abuse of discretion unless the court utterly refuses to consider the factors that go into the decision, right?
I think that makes sense. It would be a case-by-case analysis. For example, in the context of a divorce case, there might be a parallel criminal proceeding in the form of a domestic violence case. And I have yet to have a divorce judge stay a divorce action because there's a pending criminal case. However, in my experience, when it comes to, civil cases, a lot of judges are amenable to staying them. And in this case, based upon my review of the record, I'm of the impression that our trial court judge didn't review really any of the factors and refused to stay the case.
Your Honor, I've got a few thoughts on that, Judge Yates.
Can you wait until
Oh,
we finish this argument? Sorry.
Um,
I have at least one more question for you, Mr. Bristow. I'm a little confused about the status of this summary disposition motion under C8, because it seems to me that if the case is going to go forward, there ought to be some threshold determination about whether it's even viable. Now, the last representation that I found in the briefs is that it was noticed for oral argument on Friday, January 5th. Everyone convened, and then the judge indicated that she wouldn't decide it because the case was pending on appeal. Am I right about that?
Close. The trial court judge refused to decide what to do with the pending motions for summary disposition. However, she also made it clear that discovery could otherwise proceed.
Right, but I take it that part of your position is if the judge would just go ahead and hear the C8 motion, the whole case might very well be over, and then we wouldn't even have to worry about the implications of invocation of the Fifth Amendment in the context of the civil case, right?
That is correct. And one of the federal cases I cited, I don't recall which one, involved that very issue. A stay was ordered, and then the parties agreed, to my recollection, that the stay could be vacated to the extent that a dispositive motion was going to be filed. And to my recollection, the trial court judge still prohibited discovery to take place, but allowed the parties to move forward with their dispositive motion. And we very much would like that to happen in this case, but the trial court judge would not entertain that motion, and that gave rise to my motion for a stay that I filed with this case. And this court did stay the civil case pending this appeal. Unless the honors have any other additional questions for me, I do rest.
No question. Thank you very much.
Thank you, Judge.
Can you put your appearance on the record again, please?
I'm sorry, George Danini on behalf of Kathleen Bird. So I want to pick up on Judge Yates's your comments. This is absolutely is an abuse of discretion standard. I think what's missing here and what opportunity is presented for this court is to provide guidance on the current standards that are over 50 years old. So the two cases that I think are important, and I know the court has looked at, one is Sternberg versus State Bar of Michigan. That case involved an attorney who was also charged criminally in a grievance matter. Obviously, that case has a little bit of difference because we have an attorney who has to be available to the public, officer of the court. And importantly, I think in that case, the invocation of the Fifth Amendment for that lawyer would not have resulted in disbarment. So
Maybe it's not you. Somebody said in the brief that relying on the Sternberg case makes no sense at all.
Right. Well, and even, I mean, I don't think Sternberg really cuts across. It just said there wasn't going to be a stay there. It didn't say a stay was impermissible. And then we have the Callahan case, which is also, again, a 1973 case. And there, this court said, the decision to grant or deny a stay, quote, must be tested against the equity and necessity for proceeding with the civil action under the circumstances of a given case. We take great length to go through what the federal standard is. And Judge Yates, you pointed out that there's a 5-factor test or 6-factor test, depending upon the courts that we're looking at. And really, I think that's what this court has an opportunity to do. It has an opportunity to provide guidance to trial court judges within the state of Michigan that similar their brethren federal court judges would undertake in similar circumstances. And to me, it doesn't make sense for somebody who is charged federally and or has a civil case in federal court, or it could be state court, to come up with a different result just because they're charged there as opposed to in state court. And these guiding principles, and I'm happy to walk through them, although I don't know that that's going to be necessary because I know you're familiar with them. I think that's the key, because really, yes, the transcript, the Kent County Circuit Court Judge Elmore went through some analysis. Her instinct was essentially, as I read, I wasn't there on that day, but as I read the transcript was, well, our trials are out for years anyway, so go ahead and do some discovery. And I'm going to be, essentially nice to you on the defense side because I recognize this Fifth Amendment issue. But, then you get embroiled in civil litigation. And you also have to really be paramountly concerned with the criminal case. I know Judge Yates, you spent time as a federal prosecutor, federal defender. I'm sure you've confronted these issues in the past, and guidance that a litigant, such as myself, I'm representing Ms. Burden both on the criminal case and the civil case, can go to a judge in a civil context and say, Judge, we have to put our energies on the criminal case. The criminal case is, obviously when liberty is at stake versus property at stake, we have to focus on that. And so to do something in the civil context that could jeopardize the criminal case is really not a place that a criminal defendant ought to be.
Well, Mr. Danini, I hear what you're saying, and it was my practice in all my years as a trial judge to always stay the civil case while the criminal case was pending. But I come back to Judge Murray's point, which I think is the overarching concern that all of us have. We're just looking for abuse of discretion here, and that's very hard to find. I think Mr. Bristow candidly and I think appropriately conceded that he's been involved in cases where different results were reached by different trial judges, and that's just naturally going to happen when you're balancing 5 or 6 factors, right?
Absolutely. And I think, again, the real point that I'm trying to make here is right now, trial judges in state courts in the state of Michigan are not necessarily undertaking that 5-factor analysis. And I think that's important. I think it also helps on appellate review because then if a trial judge knows what he or she needs to do and what things he or she should focus on, they may be focusing on those things, but we just don't know. And so if we can get an opinion from this court that provides that guidance, frankly, I think the federal standard is an appropriate standard, doesn't have to be followed completely by the Michigan Court of Appeals, obviously, but I think it provides context. And then, frankly, you all can do your job better because you can see, was the analysis undertaken? Were rational thoughts given on the record? And if so, I would say future cases are likely to not be overturned based on an abuse of discretion standard.
You represent one of the defendants, right, Ms. Burden?
I do, Your Honor.
Yeah. Did you have a motion for summary up too, or no?
In this case, Your Honor?
Yeah.
No, we would, we would join that, or I don't even know if we just for context, Your Honor, I was only in the criminal case. There was one law firm that was representing multiple defendants in the civil. They wound up withdrawing and kind of, after a lot of this took place, we came in not just as a courtesy, but essentially as a courtesy to the client to be able to cover both bases.
Any other questions? No? Okay. Thank you both for your argument.
Thank you very much, Your Honor.
Have a good day, everyone.
Thank you. Moving on to the next item on our docket, number 15, docket number 371262, People versus Williams. Please. Good morning.
Morning, Your Honors. I see fellow counsel is not present, so may I proceed?
Yep.
Yes, I think he asked for oral argument and we turned him down.
Correct, Your Honors. Okay, Amanda Ingram of the Kent County Prosecutor's Office on behalf of Plaintiff Appellee, the people of the state of Michigan. If this court has any questions, I am happy to answer. Otherwise, I would just stand on my brief and the fact that People v. Soto decided this very issue.
Any questions? No? Okay. Thank you very much.
Thanks for being here.
Yeah, appreciate your appearance. That case will be submitted. Moving to the next item on our docket, number 16, docket number 362866, People v. Goens.
Good morning. May it please the court, Drew Walbeck on behalf of Douglas Goens. I think I've pretty much briefed this case into oblivion. I've briefed pretty
You
much.
always do a very good job on your briefs.
Thank you, Your Honor. I think I've briefed most of the issues 3 times at this point, so I will be extremely brief. To me, the hardest sub-issue in this case is prejudice. At the end of the day, the jury was given 2 versions of events, one from the 2 victims and one from Mr. Goens. There was some physical evidence, but it really doesn't, decide. It doesn't weigh particularly strong in favor of either side. So really, it all came down to the credibility of the 2 victims.
Didn't he throw a cinder block through the door or something like that? That's pretty good physical evidence. That backs up the other side's version of events.
Well, yes, except for the fact that Mr. Goens' version of events is that he used the cinder block. He admitted that he used a cinder block to break the door. I think the important factual distinction here is where they say he broke into the bedroom once, went out, got the cinder block, and then threw it through. He says he used the cinder block to break the door, but he never actually got inside.
It's consistent with the jury's verdict.
Correct, but it's also consistent with his version.
Yeah,
Certainly,
but they didn't buy his version, so it doesn't really matter.
Right, but that's
On appeal, it doesn't matter.
correct, but that's why I'm in terms of prejudice, once we, you take out the other evidence, you take out, this judge telling the jury that this defendant is a danger to this victim.
well, it's certainly concrete evidence.
It is.
You're just waiting for that one.
And then you take out, the prosecution's closing arguments. I think it presents a reasonable probability that the jury wouldn't have believed the victims. And to me, that's the hardest issue in the case. So unless there are any questions, I'll reserve my remaining time for rebuttal.
Any questions? No, thank you for your argument. We appreciate it.
Good morning, Your Honor. Monica Wilson, Assistant Attorney General on behalf of the people. I think I briefed this 5 times. I briefed the initial and the standard 4, and then when Attorney Wilson came in, we briefed it again. And I think Your Honor's questions, I think, kind of hit this on the head. And I addressed this in my brief, regardless of his intent of throwing a cinder block at somebody, whether he just wanted to break the door or whether he was trying to hit them with it. I think that's the law school first-year definition of an assault. Like if you're throwing a cinder block at a door that 2 people are standing behind, I think that pretty clearly meets the definition of an assault. Regardless of his intent, assuming his intent really was to just break the door, we have the 911 tape where you can hear him in real time screaming and yelling. You have his confession to the officer after the fact. I think they caught up with him later the next day. So I think if we're looking at here, the jury clearly did not find him credible. So I think he should be denied relief because even assuming if there's merit to any of the deficient performance claims, which we've addressed in our briefs here, that I don't think there's merit to the deficient performance prong. But I think even if this court finds that there is, I don't think we get past the prejudice prong. If you don't have any questions, I would simply rely upon my briefs.
No questions. Thank you
Thank
very
you.
much. Rebuttal? Okay, thank you both for appearing. That case will be submitted. Moving on to the next item on our docket, number 17, docket number 364972, Shenandoah Ridge Condo Association versus Boderi. Morning. Appellant can proceed.
On behalf of the appellants, the Sharon and Donald Scrunas Trusts and Tom Gillespie. Good morning.
Morning.
There's an old saying that good fences make good neighbors, and perhaps more than the fence is required in this neighborhood. This panel is undoubtedly.
We had a case like that yesterday too.
And this panel is undoubtedly aware, this case was lengthy and involved. I think at one point, Judge Geddes referred to 17 volumes of pleadings. but the issue for this court is somewhat narrow and I think straightforward. Whether or not the lis pendens here had to be withdrawn immediately in November 2020 or only after a hearing in which the Judge Geddes made it clear that she felt they should have been withdrawn, because once that was said on the record in August of 2022, they were withdrawn. I think that's undisputed.
Right. Well, the lis pendens remained in place for a long period of time, more than a year, right, after she rendered her decision on summary disposition.
That's correct, Your Honor. There was, I think, an intervening motion for reconsideration, some other litigation going on in the interim, and I think my clients viewed they still had a colorable claim in that period.
Colorable claim because reconsideration might be granted, colorable claim because you could win on appeal. I never quite understood that theory.
Well, there have been several counsel. I wasn't the counsel at that time. I'm only here for the appeal. So I don't know exactly what the different analysis might have been, but I would just argue that, the litigation was ongoing. And I would indicate that not exactly at this time, but the statute at issue, Section 67 was amended within, a little before this case was filed, but there was some ongoing debate. The judge cited an article in the Real Property Journal, which basically indicated that site condominiums and the applicability of the statute was unclear. So I guess the issue was, I think that, maybe there would have been an appeal on that issue, that we're not appealing that issue today, but that was something that may have been available.
Yeah, the underlying theory was reversion, and there was that odd quirk in the law, which has now been straightened up. But I mean, these people who had lis pendences on their property had freestanding, fully existing condominiums for which they'd paid good money, right? And the argument on your side was all of this reverts back to the condominium association or us or whoever it was. I mean, they said you didn't have standing, but I mean, you were basically trying to take these freestanding condominiums from which people paid good money, right?
I think the clients would argue that prior to all these homes being built, there had been conversations when these units were being purchased about, wait a minute, we have questions about this, but.
Right, but the remedy that your clients were seeking was reversion, right?
I agree it was an aggressive remedy. The judge in the trial court had perhaps a similar reaction to yours.
Right.
Again, I would simply indicate that at the time, Judge Geddes, she gave a lengthy written ruling.
Yeah, 29 pages.
And in the statute, it says that the judge may direct a lis pendens to be withdrawn. That wasn't part of it. It may have been an oversight. Maybe something that one of the attorneys could have said, well, wait a minute, can you please order them to remove these lis pendens? I would agree my position may be a little bit technical, but again, we're talking about significant damages. An area where I think that the facts may not be ideal in this case, but I think there was an ambiguity. I think the reason for the 10-year rule is in part to prompt developers to complete projects.
Sure.
I think this happened during the recession. My clients bought their units in 05 and 06, I believe. Then, as we all know, the recession hit and a lot of things just kind of stopped in the state and perhaps the country. So I think that there was a unusual set of facts that don't come up. I've done some condominium work in general, and prior to the recession, developers wanted to get things done quickly because they wanted to sell, whether they're doing attached or site condominium. So this is just kind of a situation probably wasn't even expected by the drafters of the act. I can't speak for them, but
certainly not expected by the people who bought the condominiums.
I certainly understand that, Judge. And but again, I just would point back to MCL 600.27251, which indicates that the lis pendens stays in place until the case is settled, there's final judgment, or the court directs that it be released. The court from the bench, before even an order was signed, said release. And one lis pendens, not an issue here, was released earlier. But when Judge Geddes made that direction, it was done. And that's where I think in my mind, the strongest point my client has is that maybe you could question the rationale between November of 2020 and August of 2022, but when someone with, a judge said, this is what you have to do, it was in fact done. Again, I think the law, not maybe some of the facts here, but the law was ambiguous. There wasn't a lot of direction. The term site condo simply doesn't exist in the statute, though it's a very common form of residential development in Michigan right now. And I think it creates some issues. I think that the concept in as I read it anyway, was that the development of condominium means you see buildings attached to each other that are, are done. And that's not always the case when you simply are building roads and then folks hire their own builders to build their own homes, which is what often happens in a site condo situation. So again, I would argue, Your Honor, that my clients did not act with malice. These were not false lis pendens. There was litigation that would impact these properties, which is what the lis pendens is meant to provide notice of. There was a lack of mitigation, a motion to Judge Geddes, maybe 3 paragraphs could have said, Judge, you ruled this way in November of 2020. These lis pendens are still in place. Are you asking that they be removed? That could have been done in very little time. So I think that the amounts awarded were excessive, and I would ask that this court either reverse that award or remand the issue back to the court on that issue alone. I'm happy to take any more questions or reserve my time for rebuttal if there's no questions.
You have plenty of time for rebuttal.
Thank you.
Morning, Your Honors. Kevin Gentry on behalf of appellees McRobbie and Flynn.
Morning.
According to Wells Fargo, in the absence of judicial decision otherwise, the malice necessary for slander of title does not exist when the offending party's actions rest on a rational yet incorrect interpretation of the law. Well, that cuts against the appellants here twice. First, there was a judicial decision, and second of all, the judicial decision suggested, as I think Judge Yates may have been approaching, that the interpretation was a little less than rational. It's pretty out there. This was a extremely aggressive case. There's probably a reason why it went through an army of attorneys, because they couldn't find people to stand up and say this all the time. But in the end, the lis pendens sat there for 2 years, and my clients were prevented during a great opportunity for refinancing with rates that will never be seen again, probably, from doing that. They had affidavits, they're in the appellee's appendix, and that's really all I have.
Any questions? Okay, thank you very much.
Thank you, Your Honors.
Mr. Gentry.
Any rebuttal?
Again, I think with the Wells case.
Please approach
right, we
the
can't pick you.
lectern.
I'll be very good. I just went on case law, Wells and other places. I believe that the case law does require that there be some clear statutory requirement. And I know that counsel didn't cite this case in his argument, but the Anton case that they cite, Sowerby, involves a statute that says when there's money put in escrow, release a lien. There isn't a statute here that said my clients had to release their lien. There wasn't an order until August of 2022. And so I think that there was a basis to believe they were not committing a violation. So thank you.
Okay, thank you very much. Thank you both. That case will be submitted. That brings us to the end of our 10 o'clock docket. Is,
Mr. Bean standing by, if you'd like to proceed with that.
yeah, let's
But we
go
can
ahead
stay
and
with this one
proceed.
as well. She hasn't been here.
I'm sorry, say that again?
And the second case, I believe that attorney was walking, and she has not something.
Okay, perfect. Then let's go ahead and call the next case, unless either of you need a break. You're good? Okay, we'll call number 18, docket number 371050, Faber versus Faber.
Yeah, for a second.
There we go.
Good morning.
Good morning, Your Honors. My name is Daniel Mead. I represent Christopher Faber, the appellant in this matter. In reviewing and preparing for today, I have nothing to add for oral argument. I'm happy to answer any of Your Honors' questions if you have any.
Okay, any questions? Nope. Okay, thank you, Mr. Mead. Appreciate your appearance. That case will be submitted.
Thank you, Your Honors.
I just think that she was.
Let me go ahead and go out of order and call number 20 because that case is going to be submitted on the briefs. Number 20, docket number 371050, 325 in Ray K minor. That case will be submitted on the briefs. And then we will,
She is here now, yeah. She's
She is?
getting up to the screening.
okay, great. Well, do we want to take a short recess and come back, or do we want to just wait for her?
I have to wait.
Okay, I'm good with waiting.
Right
too.
out there, right?
Yeah, we'll just wait a few minutes.
She's joining right now.
Wonderful, thank you.
I'll let you know.
Tell her when she gets in here that she's late. You're late, we're waiting for you. See, you are, this is close to a record. It's
It
gotta be.
is.
It's, yeah.
Except for Mike Talbot.
Good morning, please. Come on up. Good morning. You can take a minute to
Awaiting your arrival.
settled in.
So sorry, I had 11. I'm so sorry.
No.
You
It
were
is
right. It is
11.
11. We just.
Yeah, you're
we just
early. We're teasing
blasted
you.
through our 10 o'clock docket. Yeah, go ahead and take a minute. Yeah. Take a minute to get situated.
Thank you so much.
Thank you for being here early.
Yes.
Yeah.
It was, I was driving in from Cadillac, so I wanted to make sure I gave myself some new wiggle room, and I have a client that's a kick from jail and needed to go downstairs, so works out well.
How was the drive?
It wasn't too bad. It wasn't as bad as it could have been.
Good.
For
January?
January.
Yeah. You know, speaking of fast oral arguments, after back in like 2008 or 9, when the cars were taken away, Calvin had a case call up in Lansing. He was so irate that it literally took 15 minutes, and it was a normal. He just like read the riot act and said, "You come up here and you only tell us exactly what we need to know." And everyone was, I wasn't there for it. I'm laughing because of, I would have hated if he did that, but just envisioning him doing that. And literally the case call was done in like 15 minutes. Only Talbot would do that.
You're welcome. I'll call the case officially. Item number 19, docket number 371221, in Ray TG minors. And please approach the lectern.
Greetings, and may it please the court. We appeal the decision of the trial.
Put your appearance on the record for me first, please.
Thank you. Taylor and Anna Fervento, P 83907. I am appellate counsel in this matter. I was also counsel at the trial proceedings, and I continue to represent respondent mother in the trial proceedings.
Thank you.
Thank you. We respectfully request that this honorable court overturn the decision of the trial court in this matter. Specifically the decision to remove the children. We ask for removal on, or we ask for overturn of the removal on 3 grounds. First, the trial courts committed substantial error and clear error in finding, I apologize, give me a moment. First, the trial court committed clear error in finding that there was substantial risk of harm to the children if they were to remain with mother. Second, the trial court committed a due process violation by refusing to allow cross-examination of a key witness of the department as to the removal.
And finally, the court violated the In re Williams standard in applying LaFleur to the oldest child. Would the court like a brief recitation of the facts?
No, I would like an update on where you are though, because this is obviously adjudication, not disposition. What is the permanency plan right now?
Thank you. As part of a plea agreement, termination was removed. Mother entered a plea to adjudication, a no contest plea, if I believe correctly. The children are still removed. My client is attending remotely today. I believe she's going to try to view arguments, or at least after the fact. She has done an excellent job. She's attended all parenting time. She has been attending doctor's visits. We have had disposition following her plea, and the goal is reunification.
Oh, okay. So
So-
as you're moving forward now, there's no termination petition in play.
The termination petition was I apologize. Yes, the petition was amended
With-
and
withdraw-
termination was removed.
Okay, so termination's been removed and reunification is the permanency goal right now.
The children are still out of the home, though.
What's her visitation schedule
She
like?
sees them once a week on Wednesdays, I believe, and also at doctor's appointments, the
Are these supervised or unsupervised?
supervised.
Okay.
I believe we did move to supervised or unsupervised at the discretion of the department at the disposition, but I would have to check my notes to be sure. And if the court would like, I could double check that.
No, that's fine.
Thank you. But these children are still out of the home. At the end of the day, removal did occur, and we did end up entering a plea as to jurisdiction for adjudication.
What was the basis of the plea?
We did no contest to the petition.
But was the allegation drunkenness, cruelness, depravity, or whatever, or the other one?
Improper supervision based entirely on the fact that children were injured.
Okay, so, and we're talking about the two younger ones, not the 7-year-old.
Yes, well, then there was also an amended petition as to the 7-year-old related to some allegations that were not in this petition that was filed after, I believe even my appellate brief was filed.
Okay, so all three children are plainly within the jurisdiction of the court now.
That is correct. We still do contest the idea of removal. There was no evidence presented that my client had any notice that any of the people supervising her children were any danger to the children. At trial, the clear error was.
So you're not disputing that there was substantial medical evidence of serious injury to the two younger children?
We do not dispute that the children were injured. The key issue at removal was whether or not mother had any notice that any of the people supervising her children were dangerous.
Sure, because I think the allegation is that she didn't inflict the injuries.
That is correct. We have no idea who did this. And that was essentially our argument, is we have no idea who did this. The children were in the care of mother. The children were in the care of mother's boyfriend, of mother's roommate. That was all put on the record. One of the children, the younger, was in the care of a neighbor approved by the department when mother was here in Grand Rapids tending to the older child after she passed out and her injuries were discovered. We have no evidence that any of the people around these children were more or less likely to have caused this injury. And we had no evidence that mother had any notice that any of the people caring for her children would seriously injure them in this way.
Evidence that some of these injuries were caused over a period of time.
There was that suggested via the hearsay statement reporting from Dr. Sims' report here in DeVos. That report was testified to briefly at the initial removal hearing, but then when the continuation happened, we still did not have that report. It was believed that they were caused over over a period of time, and we know these children were in the care of several different people over that period of time.
Against your client's position, because the court could reasonably conclude that she should have noticed and seen something regardless of who it was supervising when it happened, and so let's take the kids away while we figure this out.
It was uncontested that the only notice at any point that anything happened was after the one daughter reportedly fell out of a high chair while in the supervision of the boyfriend. Then the only other note, and then my client did take the child to the hospital following that incident and she was sent home. The doctors didn't find anything. They didn't do a brain scan at that time. They didn't look any further into it. There was testimony as to other doctor visits after that where my client was concerned because her children were not acting normal. She went to a different hospital because she was unhappy with the first hospital. And still, she was sent home. There was dispute over whether or not that was for the flu or was for something else, but the children were acting strange. My client observed that. My client took them to a hospital and she was sent home.
Well, let me ask you this, because one of the elements of evidence established that I think it's SG was severely malnourished. Now, I can understand how you can argue that a brain bleed or something like that wouldn't have been readily observable, but severe malnutrition is much more readily observable, right?
So that was based purely on height and weight for SG. My client is not a particularly large person. I believe SG was about 2 years old. I'm sorry, 2 months old at the time. The child that was allegedly severely malnourished, if I recall correctly, was a younger child who was only a few months old. And that was based purely on height and weight of the child.
But the child did gain substantial weight almost immediately after being hospitalized and was then being properly fed, right?
I don't believe so, unless I am incorrect.
Okay, so if the record establishes that the child had gained 4 pounds since being hospitalized, that would be significant, wouldn't it?
It could be, but the question is, did mother have noticed that the child was malnourished? If the mother observes that the child is being fed, the child is taking bottles, the child appears to be eating normally, but the child is not gaining weight, especially a child that young, is that substantial risk of harm? Is that something the mother is causing, or is it a pre-existing medical issue of the child? You know, I have a 6-month-old at home, and if she is eating and she appears normal and happy and healthy, I am not going to have reason to think anything is wrong unless or until we get time for a pediatrics appointment and they tell me she's underweight. There was no evidence that mother had any notice that the child wasn't gaining weight until she went to the hospital per DHHS's request, and had a brain scan on the younger child, which was when the younger child's injuries were discovered. The only evidence that mother, and this gets to my second point, the only evidence that mother ever refused any medical care or did not act as a reasonably diligent parent was the allegation of the father of the younger child's girlfriend that mother refused a brain scan at some point prior to the brain scan where the injuries were discovered. But there was no medical record or testimony as to medical records, doctors, or anyone of that nature who said mother came in and mother refused a brain scan. There was no evidence to that. The only evidence was based on the statements of Ms. Vollmer. Ms. Vollmer had sent my client a text message effectively saying that she would do whatever it takes to make sure she doesn't get her children. And I was not allowed to properly cross-examine the DHHS worker on Ms. Vollmer's admitted bias and admitted dislike of my client due to the fact that her boyfriend conceived the younger child while Ms. Vollmer was dating her. And I was not allowed to properly cross-examine to that, which would show clear bias. And if that is the only evidence that my client ever refused any medical care, there is a due process violation there and not allowing proper examination. Now, if the court had allowed the examination to go forward and then said, I'm not going to weigh it the way that I want you to weigh it, Ms. Fierveno, that would have been a different issue. But we were not allowed to cross-examine on that. The objection was sustained.
On relevance grounds, right?
On relevance.
So it'd be abuse of discretion review.
Yes, we would ask that that be an abuse of discretion. And finally, we would, going back to the substantial risk of harm issue, the department presented evidence that my client certainly was not mother of the year, may have made mistakes in hindsight. We don't deny that, but every parent makes mistakes.
Well,
every parent does things wrong.
Let me ask you this, because as I understand it, the father of 2 of the 3 children is a registered sex offender.
That is correct.
And I think there was a great deal of concern that she was in some sort of romantic relationship with him still, and she denied it. But the kids disclosed that they saw her kissing him and things like that.
I feel like that boils down to the relevance of that issue. At a later hearing that was addressed, and my client admitted that the younger child was conceived in a sexual assault, and as that was her story on the stand related to us attempting to. But there was, at the time this petition was heard, there were no allegations of failure to protect from CSC. There was later an amended petition where those allegations came in. However, those allegations were known to the department and being investigated by the department at the time they filed this petition, but they did not include them in this petition or seek them as grounds for removal. Is it a poor choice in romantic partner? Yes, but that does not lead to the conclusion that someone would then violently attack a young child. And the removal was not based on CSC allegations. The removal was based on the fact that these girls had injuries and we had no idea where they came from. We had no idea who did it. And if we're looking at the substantial risk of harm issue, we can, as someone who works in child protection law and as someone who has young children, I understand the tendency to be a helicopter parent and want to protect them from all possible harm that could happen. I fully understand that, and I greatly respect this judge as a colleague. The trial judge is one of my mentors. That said, we cannot be a helicopter judicial system. Some children will be hurt, and there is nothing that could have been done reasonably to prevent it. There are situations where bad things will just happen. And there's nothing the parent could have reasonably done to prevent it. No evidence was presented at the removal proceedings to show that my client did this or to show she had any notice that any of the people that were around her children were violent or dangerous to children. No evidence was presented that she ever acted improperly as to medical care. When she found out her child fell out of a high chair, she took him to the doctor. When the child was acting ill a few days later, she took him to the doctor. When the child passed out, EMS was called. She took them to the doctor. She sat at her daughter's side wanting to know what was going on with her daughter. She has gone to as many doctor's appointments as she possibly can, given her limited resources in the system. She still finds a way to get to doctor's appointment after the children have been removed, go to the doctor's appointments, learning how to care for them with these injuries, going to every single parenting time that has been offered since they were removed back in May. She is a very diligent mother and loves her children. The only evidence that she ever did anything improper was based purely upon the alleged statements of Ms. Vollmer. And there wasn't even testimony that Ms. Vollmer was even at this doctor's visit where this refusal of medical care ever occurred. The testimony from the DHHS worker at trial proceedings was that he asked her to go to the emergency room with the younger child, and she did. And she then brought them to the emergency room here in Grand Rapids. It's an 1.5-hour drive. She brought them here. The brain scan was conducted and the younger child's injuries were found. She did everything she could to comply. She did everything to get medical care. There was no evidence presented that if she had acted any differently, these children would not have been injured. There was no evidence presented that she was on notice that any of the people around her children were violent or had a violent history. The only evidence presented was that at some point the boyfriend was investigated for malnutrition, and then there was an allegation based purely on height and weight of malnutrition of the younger child. There was no allegation, though, or testimony from the older child that the children weren't being fed. There was no testimony from a CAC where he was saying they weren't being fed. And the older daughter, there was no allegation that she was malnourished, the one who passed out.
The 7-year-old.
No, there was a 7-year-old and then I believe a 2-year-old and then a 2-month-old, 3-month-old.
I was trying to figure out which one you were talking about.
Oh, I apologize. So
the injuries were to the 2 younger ones. There was no
Yes.
injury to the 7-year-old.
yes, there was no injury whatsoever to the oldest child at the time of removal. There was no allegation he had been injured. So there are 2 boys. The one boy was living with his father and was not part of this matter. The second boy was living with my client and he's a 7-year-old, I think now 8-year-old. And then the 2 girls, who one was a couple months old and the other was 2 years old.
Ms. Fiorvento, you have about a few minutes left of your argument.
Yes, thank you. So finally, and that gets to my final point with the with the older boy. There was no evidence that he was injured in any way. The allegations of injury were purely for lack of a better term, shaken baby, he was past an age where that would apply to him. He was 7 years old at the time. There was no allegation that he had been physically harmed in any way. There was a CAC interview. There was all of that. There was no admissions that anyone attacked him, hurt him, that he witnessed anything. The only allegation really that came out is that at some point in the past, he saw his mother kissing the one child's father. And while that might not be appropriate, that's doesn't mount to that high barrier of taking a child away from their parent, their parental home. For those reasons, we believe it was improper to apply LaFleur to the older child. And I would also emphasize too, by the time this petition was filed and heard, which was quite a while after I believe about a month after the initial injuries were discovered in the older girl, she had moved out of her apartment. She had isolated her family from the people that potentially could harm. Her children were only in her care after she learned that someone injured them. She took all reasonable steps that would be expected of a parent who unfortunately found themselves in this situation. I specifically asked the worker, well, what if I leave my child at a licensed daycare and my child is injured? The theory of the case of DHHS was because you are a parent, you are responsible to everything that happens to your child. And if your child is injured, your child should be taken from you, which was effectively their argument. I vehemently disagree with that. I asked the worker, what if I leave my children at a licensed daycare and they are injured? Are you going to remove my children then? And he said no. And when I pressed more on, well, what if it was with a family member? We really couldn't get further in that due to objections. Some children will be injured. It's unavoidable. But all we do is compound the injury and harm to those children by taking them away from their family, unless we have some evidence that the parent could have prevented the injury. Here at the removal, no evidence was presented aside from the very biased statements of Vollmer that my client could have prevented this. But there was ample evidence that she took her children. We even brought in the roommate. She took her children, who was a witness that she took her children to the hospital. She called EMS when the child passed out. She
Already told us all that.
All right, thank you. I do apologize. Well, I have nothing further. Thank you, Your Honors.
Thank you very much. Thank you for your argument. That case will be submitted. And that concludes our call for January 2025. Thank you.
Thank you for getting ready quickly. We appreciate it.